have lots of information to share, but I'd much rather have a conversation. So please feel free to interrupt me. I will just say that my tiny brain is not able to monitor both the chat and the slides at the same time. So just feel free to break into the conversation orally, and I'm very happy to take questions as we go. I'm a torts teacher. I teach the law of personal injury liability here at Stanford Law School, and my scholarly interest has long been in understanding how the forces of legal risk management shape the delivery of healthcare. I've gotten interested in how that intersects with our adoption and use of AI in recent years. And I'm very happy to share with you some of the research that I've done about how this might work, particularly in the realm of generative AI. I thought it might be helpful to kind of start off with a few broad objectives. Maybe to frame our conversation, it might be useful to ground our thinking in a couple of the predominant Gen AI use cases that are increasingly prevalent in healthcare today. Ambient scribes. And let me just pause and ask, do you have an ambient AI scribe in use at the Hutch now? Anybody know?
My understanding is that there are some trials.
Okay, great.
Yeah, we're rolling out a bridge right now at Fred Hutch, so I believe it's going live over the next month or so.
Perfectly timed then. And the second is something that's happening everywhere, which is that physicians are using large language models like ChatGPT to do a variety of things. At Stanford, we've created a secure instance of that to protect our patient data. At other institutions, it's more sort of open web searching. But again, very, very common. I'll talk about some of the uses there. And with that background in mind, I want to talk about some steps for managing the risks that are associated with these types of use cases. And I'll end with just a couple of comments on what might be coming down the pike from a regulatory and policy perspective. So to start us off, as you know, generative AI use cases are increasingly permeating healthcare. This was from a survey last year of where major healthcare organizations are in their adoption of healthcare AI tools. And what you see here is that that clinical summarization tools like AI scribes are really at the leading edge of this. Their patient email drafters are also pretty popular tools for healthcare organizations to be adopting. Let me just pause. Are you, like me, seeing like notes alongside these slides, or are you just seeing the slides themselves?
I'm just seeing the slides. No
Okay,
notes.
great. Perfect. So what are we talking about when we're talking about ambient AI scribe tools? This would be a typical setup for a tool of this kind. This particular one is DAX Copilot, which is one of the more popular tools. It's something that we've adopted here at Stanford Healthcare. But the general idea here is that the tool uses one form of AI to generate a written transcript, a full transcript of a clinical visit conversation. And then it uses a different model to generate a summary of that conversation, and then it interacts with the electronic health record to push snippets from that summary into the appropriate parts of the EHR. Finally, before it officially becomes part of the EHR and visible to patients, a clinician has to review and sign off on what the tool has done. So why are organizations interested in this? I think it'll be readily apparent to anyone who has even passing familiarity with clinical medicine. That is that it really is holding a lot of promise to reduce a major source of physician burnout, which is the so-called pajama time required to enter clinical documentation into the record at the end of the day. There's also the prospect that having a tool taking notes for you might be able to return your own attention to the patient during a clinical visit and away from the computer screen. And finally, there's a recognition that some clinicians are better than others at taking clinical notes in a manner that is interpretable to other clinicians who are part of the care team. So depending on the clinician, there might be the possibility of actually improving the quality of notes and supporting better quality of care in team-based care situations. What do we know about how these benefits actually materialize in practice? The research is actually pretty interesting. There are lots of small studies. I want to share what I think are some of the better studies in this area. So the first of these was a study out of Kaiser Permanente that looked at rollout of actually 2 different scribe tools in the first year at KP. Nearly 7,300 physicians used these scribes, and about half of those physicians chose to use them in 100 patient encounters or more. What the study did was compare the high users, those in that category, to non-users, kind of dropping out the middle group of occasional users. And what they found is that the amount of time saved per note was really quite small, about 42 seconds per clinic visit. So in a day where you have 20 clinical visits, that adds up to a savings of 14 minutes at the end of the day. So that's not a whole lot more time that the physician gets to spend with her family. Even though these differences are small, though, they seem to be quite meaningful to physicians. The physician survey results reported here are from a very small survey, and possibly there's some positive response bias here. But physicians, as you can see, rated this tool really highly, both in terms of their overall work satisfaction and in terms of how they felt it improved the quality of their interactions during the clinic visits. They also surveyed a small number of patients in this project. And it was interesting to me that although 84% of the physicians felt it improved the quality of physician-patient interactions, only about half the patients reported that the doctor had looked at the screen less. So in summary, doctors at Kaiser Permanente had a very positive experience, although it didn't garner many time savings to them, and their experience was a little bit more positive than the patients. A second study recently came out of Mass General Brigham in Boston, as well as Emory, so 2 big academic medical centers. This was a very large sample of physicians, but the response rate was pretty low, around 30% at one institution, 22% at the other. So I would consider this a study that probably has some response bias embedded in it. The participants also were voluntary participants in a pilot. So I think about this study as presenting probably like the best case scenario of results given these particular selection and response biases. And what they found notably was about half of the physicians chose to use the scribe for most or all of their visits. So that's kind of a glass half empty, glass half full finding. Half of them liked it enough to use it all the time. Half of them seemed to have not used it at all or tried it and determined that it really wasn't helping them. And physicians also gave mixed feedback about how much it affected time savings and their overall clinical efficiency. And that seemed, based on free text comments, to depend on 2 things. One, how careful an editor was the doctor. As you might imagine, some clinicians are pickier or more conscientious than others about editing draft notes before they click submit. And the second, interestingly, was the type of visit. That physicians who were in some specialties reported this was just much less useful and less accurate for them than others. And in particular, visits that entailed palliative care discussions or goals of care discussions, or pediatric physical exams, or psychiatric care those were settings in which the clinicians rated the utility of the tool as relatively low. So what should we make of this research? I think it raises more questions than it answers. But this, combined with investigations that we've done here at Stanford, raised the prospect that these kinds of tools might have limitations for a number of specific contexts, including some that I've discussed already. And then here are some other possibilities that have popped up here at Stanford. When you have more than 2 speakers in the room, when somebody's got heavily accented English, and so on, the potential for errors in the transcription and the summarization seems to be higher. And then you have this question of what function is the human in the loop serving? And again, we know some clinicians are going to be willing to spend time on this at editing business more than others. So there are some risks, even though ambient scribes are typically characterized as a low-risk tool. We all know that clinical documentation can play a critical role in supporting care decisions down the line, particularly when a patient's being handed off among caregivers, members of the care team. So it's important that these things are right. Let me move on now to the second use case that I want to ground our discussion in, and that is physicians' own use of large language models to perform a variety of job tasks. Based on our use of these models here at Stanford, again, we have a secure instance so we can kind of track what people are asking it. These are some things that pop up often in our own clinicians' use of our secure instance of ChatGPT. I want to focus on the second one, suggesting diagnoses and treatment options, because I think this is the area where there's probably the greatest amount of risk associated with letting physicians in the system use tools for this purpose. So what should we be thinking about in this area? Well, I mean, I think it's always important to start with the question of like what are the benefits, because it's easy to get tied up in the the alarmist thinking about the risks, but physicians, of course, find value in LLMs, as we all do, for executing certain kinds of tasks. This study asked a sample of over 100 physicians, why do you like to submit queries to large language models? And you can see there's a range of responses, but it's both that it helps me answer questions quickly and easily, and that it allows me to assemble and synthesize a large volume of information. So there really are clear benefits to physicians. What do we know about the performance of LLMs for the common purposes that I've said physicians use them? Well, there is a very large number of studies at this point examining LLM performance, but they're concentrated in specific areas. So the evidence base is very strong in some areas and practically non-existent in others. To be a little bit more specific, this large study looked across 519 different studies evaluating LLMs, and found that overwhelmingly the literature is concentrated in a narrow set of tasks. Almost all of these studies have just asked LLMs to essentially answer questions the way you would on a board of medical licensing exam. There's like a standardized vignette, and you have to come up with a diagnosis or treatment or other medical judgment. Importantly, only 5% of the studies examined the performance of LLMs in analyzing actual patient data to come up with the answer to a clinical question. And only 16% of them looked at whether there was bias in the performance of LLMs across important groups of patients. So we know a lot about how well LLMs do at taking medical board exams. They do just as well as humans, if not better in some cases. But for a lot of other things that physicians are using them, we know very, very little at this point in time. This is another study that I found rather compelling. This study compared 9 different LLMs, including the first version of ChatGPT 3.5, which, it has to be said, is quite inferior to the newest version, in tackling a complicated task, which was to make a diagnosis after being provided access to multimodal data on real patients. And there are some pretty significant findings here. Perhaps the most notable one is that for everything except diagnosing appendicitis, humans outperformed the model, as you see in the graph here. But interestingly, there were also big swings in diagnostic accuracy when the prompter for the model changed the instructions, or the order in which the model was told to look at different pieces of patient data in the medical record. And perhaps even more perplexingly, the more pieces of information in the patient's medical record that the model was given access to, the worse it performed. So these sort of surprising and concerning findings led the authors to the conclusion that is highlighted here in the orange box, that for complex tasks that involve searching over a medical record to generate diagnostic decisions, LLMs, at least in these early forms, were not really up to the task. Again, there are lots of improvements in LLMs, but a study like this would be really juicy evidence at trial for a physician who had relied on an LLM to make a diagnosis. So to summarize, there are a number of concerns about clinicians' use of GenAI. I've talked about some of these. I think that others are probably very familiar to this group since you've been studying these issues for some time. But there are a number of reasons to be concerned about over-reliance by physicians on LLMs to answer clinical questions. Let me pause there and ask if there are any questions or points of curiosity about any of the information so far.
So I'm curious about comparison with answering medical questions as for a board versus real patient data. So do we have sufficient gold standard data on how accurate are providers in diagnosing patients correctly? Because that would be the
So
gold
that's what
standard.
this study kind of tried to do, was have an expert panel of human diagnosticians. Do you guys still hear me?
Yes, yes. We can hear you. Can you hear us? Okay, what is everybody seeing? Do you hear Dr. Mello?
See her. Dr. Mello, do you hear us?
I think her screen has also frozen for me now.
Me as well.
Let's just give it a minute. Does anybody else have any other questions or comments while we wait for her to come back? Or anything you found surprising?
I thought it was interesting to hear how many providers actually found the program like useful and how often they would use it. I thought that was really interesting.
Yeah, and I would have expected that they would save more time, right? I was surprised to see that they only saved 42 seconds per note.
Yeah, I would have thought it would have been more time too. I thought it was interesting that the patients didn't feel that there was much of a change in how much time they felt they got with the provider as opposed to screen time. So anyway.
I guess go ahead.
And she may have covered this in the beginning, but I had to step away for a quick second. What does this tool look like? I mean, is it just something they use on their phone, or is it an actual device that they're using in their visit with the patient?
So does anybody know more about the ambient listening devices? Exactly how do they function and how do they tie into Epic?
Yeah,
Is
so
it just app?
the Bridge version that Fred Hutch is rolling out right now is connected to the provider's phone. They turn on the program and app on their phone, and then it is connected to Epic. So I haven't had a medical provider for myself use this, but I have had my vet use it before, and they didn't look at their phone or computer once during the conversation. So I think I was also thinking that it was interesting that the patients didn't have a stronger reaction to it. That surprised me. Anyway.
Thank you.
And I guess it may depend on the specific rollout in a specific organization.
Maybe I missed this too, but I'm curious if the patients have to like consent before being recorded or like with this tool being used.
That would be the perfect question for Dr. Mello, because the patient rights and what are the laws around it, right? We hope to have her back soon, but I would imagine so, right? That they have to consent.
I've had a provider use it in one of my appointments, and yeah, they had to ask me. I didn't have to sign anything, but they did have to verbally ask me if I could. I don't know, maybe I did sign some. I don't recall, but I did have to give permission.
trying to keep an eye on my email in case she contacts me on email. Let's give her a few more minutes. And she did send me her slides as well, so we could take a look. Let me ask you while we are waiting, so about this topic, or are there any other topics that you would want to hear about in the future?
It looks like Sean has one.
I was being polite with my hand up, Sonali, but
Oh, sorry. I'm
don't-
trying to multitask. I'm trying to find her slides and I'm trying to make sure that she's not trying to reach out to me. Please go ahead, Sean.
No, so I would be interested if we could talk to peers of ours or other clinical operations and how they're addressing both AI policy, but also the number of tools, right? So we've got diagnostics, we've got billing processing, we've got AI in patient care settings with ambient listening devices, order management, and then Epic made a huge announcement at their UGM conference with all the updates that they're making for that. I'm just curious, as we take this journey together, do we have other partners or peers that are ahead of us or could help us with what they've learned? And I worry we're taking on this journey with this flood of tools that we're not prepared to completely. We want the benefits, we want the productivity, we want all the capabilities that these tools provide, but we need the controls and safety and the guidance to align to that. And it feels like that would be really something that we could find partners or peers or start to look ahead and how to we think of our own roadmap.
That makes a lot of sense, Sean. So our last speaker from Mount Sinai kind of was in that direction to understand what they are doing. And we are hoping to have him back one of the following months. If anybody has contacts at Epic to invite somebody, please let me know. That would be wonderful to hear from them as well. Okay, so how should we proceed? I do have her slides, but without the speaker, I don't know if that. Oh, she's back. Okay, awesome. Can you hear us, Professor Mello?
Oh, sorry. Hi, I was on mute. Hi, everyone. Yeah, I seem to have had a total system failure here at Stanford. So if you could put the slides up, maybe I can just keep going by phone, and I'll see if I can get back online. But I had no internet.
Let's do it. Thank you so much for joining back.
Yeah. So you were asking me if there had been sort of any benchmarking of the humans, and in that one study, they did have a sort of panel of specialty-specific expert diagnosticians that was supposed to be the gold standard, but of course, no human is infallible. But they were comparing sort of ordinary clinicians to that expert, like gold standard panel of diagnosticians, and that was kind of as close as they could get. Okay, so let's move forward. There's a red slide, a few slides down I want to start with. If you just keep going.
This one?
No, keep going a little bit more.
This one.
Yep, that one. Sorry. Okay. The one that's all red. Yeah.
Yeah. Do you want to do a show? I can do like this.
Yes, that would be perfect. Thank you.
Okay, awesome.
Yeah. So maybe we can talk about sort of with this background on the evidence about the benefits and risks of these tools, how I would sort of think about managing those risks or evaluating these tools in the aggregate as a lawyer. So if we get to the next slide, you know, I want to start by acknowledging that there's a lot of fear in this area, and I'm sorry to say there are lawyers who are making a very nice living freaking people out about the potential liability around AI adoption. These are quotes and images from a continuing legal education program. And in this one from the American Health Lawyers Association, you can see that AI innovation, it has this kind of, you know, mushroom cloud of catastrophic potential legal consequences around it. Another speaker described this as a potential disaster for healthcare providers. I think these are overstating the amount of concern that we need to have about the legal ramifications of AI. And we will certainly at some point be in a future where not having AI itself will be a form of medical malpractice. But I do understand the fear that comes with something that's novel and uncertain. And I actually think there are some good reasons to worry to some extent about legal risk management. So moving to the next slide, there are a number of reasons why there might indeed be special risks associated with this type of technology. And you can feel free to go ahead and click through the next few points. But one problem is, as you know, there's like most of this technology is not FDA cleared. It hasn't been through clinical trials. And so there just is a lower knowledge base about things that could go wrong. And it's only natural then that we should be concerned about the downside risk, remembering that that means not just the risk of lawsuits, but hurting patients. We don't get sued until somebody gets hurt. Because of the scale of AI and the fact that we're using it to do many things to many people, there is the potential for injuries on a large scale as errors propagate potentially over many, many patients. There, I think, is also some legitimate concerns about the idea that the humans in the loop are going to be a bulwark against errors ever reaching patients. The reality is that the reason that we're interested in using a lot of these tools is that it can save time. And so to expect humans to spend, you know, a lot of time checking and overseeing AI output is maybe not realistic. Additionally, we have the problem that many institutions, certainly outside of major academic medical centers, don't do a whole lot of vetting of these tools. They don't comparison shop. They don't necessarily buy based on who has the safest product. And once the products are in place, often the monitoring consists of just answering the simple question, is it on and is it working? Not how is it actually impacting clinical care and patient outcomes. And then there's this sort of public and reputational issues. We know from survey evidence that American patients are not trustful either of AI. 60% of Americans say they're uncomfortable about AI being used in their care, or of healthcare in general. Right now, only about 40% of Americans say they have a lot of trust in healthcare institutions. And finally, when something bad happens with AI, that's the kind of thing reporters will love writing about. So these kind of events, you know, once they get beyond the hospital walls, are likely to attract a lot of attention. So from an institutional risk manager perspective, these are all very bad things. Then you add on sort of what happens when you have an area where there's very light formal regulation, people start getting hurt. I will tell you as a teacher of torts that always, when this happens, the courts create a way for people to recover in court for those harms. Even when existing doctrine has made that kind of difficult, they will create a patch to kind of fill the gap that's left by formal regulators' abstention from a particular regulatory space. And just continuing on a little bit with the slides here. Then we've got, there you go. Issues around disclosure to patients. So I've been talking about the prospect of medical malpractice claims, but when we don't disclose the use of AI in care to patients and they get hurt, an additional possibility is that they could bring an informed consent claim on top of a patient injury claim, and that increases damages. And then finally, there's just a lot of uncertainty about how judges are going to resolve novel questions around AI liability, and in particular, the extent to which they're going to pin responsibility on hospitals and physicians versus AI developers. And believe me, when I say judges are still working that out, when I talk to judges, they have lots and lots of questions about how to apply legal doctrines that are designed to deal with other kinds of products to this new terrain of software-related injuries. Okay, so moving on to the next slide, I just also want to temper this discussion, though, with This is like a slide with fewer bullet points, but these are really, really important bullet points, countervailing considerations. So based on 30 years of research into malpractice claiming and medical injury, I can tell you very, very few instances of negligent injury ever popped up in the medical malpractice system, about 2 to 5%. So even if terrible things happen a lot, that does not mean that they will become claims. Second, when we have looked through the available sources for information about software-related injuries, including AI injuries, there's just not that many instances out there yet. We don't always have access to all the information. There are certainly possible events that insurers know about that I wouldn't know about, but there just doesn't seem to be rampant instances of suing over AI so far. And then finally, as I'll talk about, I actually think it's going to be pretty hard for injured people to recover for AI-related harms, at least in the short term. If we can move on to the next slide, I'll just explain a little bit about that. I taught my first torts class last week, and this is the slide that I show on the first day. It just sort of maps out what a plaintiff has to prove to a court in order to recover for an injury. They have to prove that the defendant owed them a duty, that they breached that duty, for example, because they were negligent, that breach led to their injury, and there was a factual causation or connection between their injury and the negligence. And I think some of these elements are going to be quite difficult for plaintiffs to prove with the legal rules that we have now. Next slide. On the duty question, there are a few different issues that I think courts are going to have to deal with. One is the question of whether the developer of an AI tool could be held liable if there has been some physician involved in the loop of care, or whether that physician's involvement kind of severs the developer's duty and shifts it all onto the physician. So for example, there was a case called Sampson versus Heartwise Health Systems in 2023 involving a cardiac health screening algorithm that failed to classify a young man as being at high risk for sudden cardiac death, despite a family history of congenital heart disease. The court granted summary judgment for the developer, meaning it just got rid of the case against the developer at an early stage, holding that it had no duty to give the patient an accurate diagnosis because it had signed a licensing agreement for its tool with the clinic that gave physicians responsibility for final decision-making about each tool. In other words, sort of specified there's supposed to be a human in the loop. And the court held that was enough to sever the duty. So there are real questions here. Second question is, what happens when an algorithm is used for an indication, a use that is either outside what the FDA has approved or is for a tool that didn't go through FDA approval, as most AI tools don't. There are established doctrines in tort law that say if you misuse a product, the product maker may be off the hook if that use was unforeseeable. So that's a doctrine that the product maker might be able to avail itself of here, for example, to say that a physician over-relied on the tool or used it in a way that it never intended the tool to be used. Next, when we get to breach, there's a really interesting question about whether courts will be willing to apply rules of product liability to hold AI developers liable. This matters because if you bring a claim under product liability law, the standard of care is a little bit different than if you brought it as an ordinary negligence claim. And interestingly, there have been a number of software-related cases in which courts have refused to hold that software is a product under which we could hold developers liable. I think that will change over time. It's one of those areas where the law will give way if there's a need to compensate a lot of injuries. But for right now, it's just really unclear. And that matters for hospitals and doctors because if the developer can't be held liable, guess who will be? It'll be the users. A second issue is if we are in the land of product liability and you're trying to hold an AI vendor liable for some failure of its product, as a plaintiff, you have to show that there was a defective design to that product. And in order to do that, you have to show that there was a reasonable alternative, safer design that the vendor could have used and decided not to. Now, that's not super hard if you're talking about something like a table saw or a toaster. But how do you do it for an algorithm that, is essentially encoding mathematical patterns, potentially implicating thousands of different factors, variables? You have to identify something that's wrong with that mathematical pattern and then prove that the developer could have designed it in a different way, that is not straightforward. And so I think it's going to be very difficult for plaintiffs to do, particularly given the opacity of a lot of these algorithms and limited knowledge of how they produce the results that they do. Moving along here, this same opacity can make it really hard for a plaintiff to prove that their injury occurred because of a defect in the product. So interestingly, it's not enough for a plaintiff just to show that an algorithm made the wrong prediction for them or otherwise made an error. They have to show that it did so because of something that was so bad about the way it was programmed that we would call it defective. And again, if you don't really understand how a model works, how do you do that? Moreover, all predictive models are imperfect. None of them has 100% predictive power. So is it defective to say that in a particular instance, a model produced the wrong result? That's really not clear. Finally, it's just kind of weird for a plaintiff to sally into court and make the argument that an algorithm that on average outperforms an unassisted physician is defective. It's a very hard argument, because ordinarily what you're doing as a plaintiff's attorney is calling upon the jury to imagine the counterfactual. What would the world have been like? What would my client's outcome have been had this instance of negligent conduct not occurred? So that means that the question is, had the physician not used the AI, would the outcome have been better? Would they still have suffered the bad outcome? Again, if the model on average results in care that's better, that can be a pretty hard argument to make. So these are lots of challenges for plaintiffs to surmount. A lot of them relate to kind of what it means to design an algorithm, the opacity of the algorithm, figuring out what's wrong with an algorithm. And I think for GenAI, these issues are particularly salient, a lot of them, and compounded in certain ways. So one problem is just kind of like producing an evidentiary record is tough, given that every time you run a GenAI inquiry, you're going to get a different result. The results are probabilistic. They're always changing. These models are always learning. So how do you sort of reproduce results in a way that enables you to mount a persuasive argument about what was reasonable or unreasonable for the physician to do? And then whereas it might be relatively easy to show when a predictive model is right or wrong, for generative AI, how do what does it mean to say that it was bad? What are you comparing it against? For example, here at Stanford, when we thought about the AI scribe tool, we found that like if you get 9 physicians in a room and ask them to tell you what a great clinical note is, they'll give you 9 different answers. So what is the benchmark against which these outputs are being compared? And how do you make that case persuasively at trial? Another issue is that it can be pretty hard in retrospect to reconstruct how much a physician actually relied on the output of like a query to an LLM, unless they had the foresight to write that down. It's going to be hard to kind of reconstruct the thought process there, and that matters because what has to be proved is that the physician behaved reasonably, or if you're the plaintiff, that the physician behaved unreasonably in relying on that output. Again, just pretty hard to do. There's also, I think, an emerging issue of how judges are going to allocate liability across developers, hospitals, and individual doctors and nurses. Right now, my observation is that many hospitals just say to the clinician, look, at the end of the day, it's your license on the line, it's your butt on the line, it's your responsibility to make sure that the actions you take based on this output are correct, and that the output itself, if it goes in the medical record, is correct. And, that's in a sense a real abdication of the institution's own responsibility to make sure that it's pretty correct most of the time, just to say to physicians, it's up to you. And I think there will probably come at a time where courts find that unacceptable. And then the last kind of emerging issue that I want to point out is that there's been a very subtle but important change in the legal standard of care for medical malpractice. So if we go to the next slide, historically, as you may know, physicians have been held to the custom standard, which means that to determine whether a physician was negligent, we would ask what other physicians in the same specialty would have done in similar circumstances. There was an august group of legal scholars and jurists that was convened recently to to restate or summarize where the law is now, looking at case law. And they came up with this just ever so slightly modified standard in the beige box here. And the red words that I've highlighted, I've emphasized to point out that in this new standard, the fact that other physicians do not do a thorough job of like reviewing, considering, editing, and checking generative AI output is no defense. So even if we were to move towards a world of complete automation bias where physicians just kind of like click accept every time they get a draft visit note, push it into the medical record, everybody's doing it, still courts are not going to accept that when it comes time to judge that action is reasonable or unreasonable. Move along a little bit here. Next, it has to be said that the role of private contracting in determining legal responsibilities is going to be very, very important in the years to come. We're in this kind of period of awkward adolescence where the courts are sort of figuring out what they're going to do and regulators are figuring out what they're going to do. And during that time, developers have really stepped forward to protect themselves through private law, meaning that when they're signing licensing agreements with hospitals, they're making sure that they have in their provisions that minimize their own responsibility for things like monitoring of the tool, providing hospitals with the information that they need to train people on failure modes and do good monitoring. And then by what are, in my view, outrageous disclaimers of liability and ordinary consumer warranties around their products, as well as restrictions on product use that are completely out of touch with what they know the tools are being used for. So here's an example of the terms of use for ChatGPT. And if you click ahead one click here, you'll see, oh, sorry, go back one more. Yeah, sorry. What they're saying here is not that you mustn't over rely on ChatGPT in medical decisions, but that you must not use it to make any important decisions, including any medical decision. This has a legal effect, potentially, of exculpating them in the event that somebody does use it in this way. That's misuse. But they know that not only are physicians just using ChatGPT directly for these things, but there are tons of vendors out there that are developing custom healthcare AI tools based on ChatGPT. Notwithstanding the fact, but notwithstanding all of that, this is what vendors are doing, and it's quite common. So let's move forward a slide now. So let me turn to some risk management recommendations, and then I'll just offer a few thoughts about where I think regulation is going in the years to come. So one is that I think that people tend to get freaked out about the liability risks of AI, but it is much more useful to calibrate the level of freak out to some considered deliberation about the actual risk associated with different tools. And so if we can click through to the next slide, a few different, just do a few clicks for me on that one. This is kind of the framework that I use to think about the risks associated with different AI tools. That it starts with thinking about the possibility that the model itself might be wrong, or that clinicians make mistakes in deciding whether to follow a model recommendation or not follow it. But that's just the start. I think if we import what we've learned in other areas of patient safety research, it's also important to think about the possibility that errors are going to be caught before they reach patients, as many errors in healthcare are. And that's going to depend on a lot of contextual factors about how clinicians are using the tool. In particular, how tight is the coupling between the tool's output and the next thing that happens to the patient? Is there like a buffer in there? And what does that buffer look like? Time is one factor there. If this is an extremely time-sensitive situation, like in the ED, it's more likely that we're going to have an error reaching the patient than if it's in a clinical setting where there's time for reflection and deliberation and investigation of AI output. And then finally, related is the context of situational opportunity. Even where time is not a factor, different work settings are going to involve different likelihoods that a physician is going to notice an error in AI output and respond to it. Things like the amount of work or cognitive overload are going to be really important here. Then the next thing we have to consider, I think, obviously, is how bad is it if the error does reach the patient? How frail or fragile is this patient and vulnerable to having impacts on their health? And how important is the tool's clinical function? So these things all together, I think, are good ways of thinking about the legal risk associated with the tool, meaning the risk that it's going to harm a patient seriously. But the lawyers will then come in with one more box here, if you can click ahead one more time, just to remind you that not all injured patients make it into the legal system. And so the potential for any particular injury to find legal redress is going to depend on a bunch of other things that have nothing to do with any of this. It has to do with how easy it is to prove the case, how attractive the plaintiff is, and so on. And so sort of paradoxically, sometimes the injuries that result from the most egregious errors are not necessarily the ones that will attract compensation in the legal system for a variety of reasons. Chiefly that the people that it happens to are not great plaintiffs because they don't have big damages. For example, they're older adults or kids. Or because it's just very opaque and you can see that something went terribly wrong, but you can't really prove it in the ways that I've talked about. So all of these are, I think, the things to take into consideration when you're answering the question, is it worth it to adopt a tool given the risk? I have a few other risk management recommendations as well. I think it's really critical that institutions take active steps to confront the prospect of automation bias. By which I mean helping clinicians not become too complacent in reviewing GenAI output. And one thing that I think helps with that in particular, instead of just saying to physicians, hey, it's your butt on the line, is to make sure that you have gotten the key information from developers about the failure modes of the tool. What are the known weaknesses? What have they found that it's not so good at so far? And then train physicians and nurses to focus their vigilance on those things. So for the ambient scribe example, we might say, look, this thing is right most of the time, but if you've got more than 2 speakers in the conversation, if one of them is not a native English speaker, if they've got more than 3 complaints, or whatever it is, the risk factors for error, you should focus on correcting and like reviewing those notes in particular. Another, I think, general legal risk management point for clinicians is always that we want them to document their decisions, and that's no different for generative AI. Again, they're going to have to sort of defend the reasonableness of relying on GenAI for clinical decisions, and so it can be, in certain contexts, important to document, first of all, what was running at the time, and then secondly, why was it reasonable to rely on it or reject it. Moving on here. I think we also have to think seriously about patient notification policies because of this risk of informed consent claims. And my view over time has come to be that this should not in any way be up to physicians and nurses at the bedside. It should be a matter of institutional policy. And moving forward in the next slide, that institutional policy should reflect a sort of decision framework that focuses on 2 things. One, what's the risk that the patient might suffer physical harm as a result of our use of this tool, which includes all these factors I've talked about in the framework. And secondly, if we were to tell patients, is there anything they could do with the information? Is there anything that they could do is meaningful in terms of opting out of use of the tool, or maybe taking it upon themselves to review draft notes themselves to try to help the physician catch error? And if the answer is no to both those questions, then we have to think really hard about why are we telling patients, because we can, in some instances, just add to their burden. Instead, we might be able to honor patients' interests more by just exercising very vigilant oversight of the tool as a hospital. If we were to disclose, I do have a view about what should be disclosed, and these are kind of the basics. And I think on the next slide, I have an example of what I would recommend disclosing specifically for an AI tool. Another factor here for AI scribes is that wiretapping laws in some states, including Washington State, require patient notification if you're going to record a conversation. And so it's not an option in Washington to disclose, but of course there are better and worse ways of offering patients a disclosure, and this is an example, I think, of how to do it right. Moving on. I think it's obvious that we want to stay abreast of the best choices for generative AI tools, and it seems that In particular, tools that train on patient information and medical sources are especially promising in terms of reducing errors, but really important to look at the choice set of tools. It's increasingly common, I think, for institutions to reach for the tool that's being offered by the vendor that they know. Often that vendor is able to offer solutions at a very low price, but the real cost of AI tools is not the cost to turn it on, it's the cost to monitor it and the cost of responding to adverse events. Finally, if we move on a little bit more, I think when we think about monitoring, we have to go really deeper into questions, not just like, is it working, but what impact is it having? And I think a lot of institutions don't really have monitoring plans thought through before they implement tools. That's an area for growth. But lastly, I'll just conclude by saying, you know, all of this is a lot of work, and it would be easy to say, let's just kind of stick with the old way of doing things. But we always have to focus on what medicine looks like today. There are so many errors, so many things that go wrong in human-only care that I think it is really a question of balancing risk and benefit and trying to minimize risk rather than rejecting AI out of fear of the unknown. So if we can move forward, I'll just conclude with just some brief thoughts on where I think things might be going in a regulatory space. There's pretty widespread recognition that there are problems with what the FDA can and can't do. It operates under a regulatory authority over medical devices that was created in 1976. That's the year Apple Computer was founded. Obviously did not contemplate software at all, and certainly not AI. And so there's been efforts to try to modernize this regime, but we're definitely not there yet. My sense is under the current administration, there's not a huge amount of interest in trying to modernize this framework, but I actually did have a conversation with a Republican staffer this morning on the Hill who is interested in doing just that, who is in a leadership role. So who knows, but I think good things can happen in that space if they're willing to take that on. Their current focus, though, is much more on removing any regulatory barriers that might keep us from competing with the Chinese in AI development. So I don't expect to see a lot more regulation in the federal space. On the state level, things look different. States have been incredibly active in trying to regulate this space. Most of what they're doing kind of clumps in just a few areas. They like to imitate each other a lot. One area of focus has been on mental health professionals' use of chatbots as extenders for psychological care and curbing abuses around that, mainly focus on ensuring that there is a human in the loop overseeing the care. And then a lot of states are focusing on disclosure and transparency, making sure that people know when they are interacting with generative AI. In Washington state, there's actually been a bill introduced this year that goes a little bit farther and would require disclosure not just to patients, but to the public generally, of how generative AI systems in healthcare and in other sectors were trained to give people a little bit better sense of what the potential weaknesses might be. So I'm going to stop there. I have some other work that delves into these issues in greater depth for those who are interested, but I'm happy to stay on for a couple minutes and take questions if there are any.
This was great. Thank you very much, Professor Mello. This is like a glimpse into a whole new world because a lot of us are very focused on the applications and developing applications. So this kind of broader overview and where things are going, this was very helpful for me. We are at the end of our allotted time, but if you are happy to stay for a few more minutes, let's see if there are any questions.
Will do. Thanks very much, everybody.
Thank you so much.
Marisa says thank you, and people are reacting.
Great. Well, very, very nice to meet you all, and I'm happy to continue the conversation offline if anybody would like to reach out. Thanks for having me.
Awesome. Thank you very much, Professor Mello.
All right. Have a good evening, everyone.
Thanks. Bye.